Hi, so this is the PowerPoint and explanation on the appeal system of appeals starting from the Magistrates Court. So the first thing that we need to consider is why we have an appeal system in the first place. Now, if you're a defendant, it's really important to have an appeal system because you might actually be innocent and need to appeal to obviously get your freedom and to have that conviction overturned. So some of these cases that we've got, as you can see here, we have got the Birmingham Six. Now, the Birmingham Six were accused of bombings, and we did look at these under police powers. Now, obviously, the police fabricated evidence and put two and two together and came up with 5, and they obviously needed the right to appeal to overturn their conviction as they were innocent men in jail. Another one that you should have looked at as part of your studies on this topic area in class is Sally Clark. Sally Clark is a mother who got accused of killing her baby in a horrific circumstance, and she ended up appealing or needing an appeal because obviously she was innocent. So these are the reasons why you need it if you're a defendant. Also, you could want to appeal in case you get given a sentence and you feel like your sentence is too long and you need a shorter sentence. If you're the prosecution, you may want to appeal if you're the prosecution if you feel like that a sentence is too lenient, or if new evidence comes to light and you think it's important that the person goes back under trial for this. So you would have to appeal first before you could start a retrial. So these are some of the main points of why we need an appeal system. Now, what we're going to be looking at are the appeal functions of the Magistrates Court. Now, in the Magistrates Court, there are 2 grounds for appeal. One is on a point of law. This is where there's been a error made by a magistrate. Because if you remember, magistrates are lay people. That means they've got no legal training. So if an error's been made on that point of law, then that needs to be corrected. So there's an appeal route for that. And then the next one is an appeal on conviction and sentence. So that's if you believe that you shouldn't have been convicted, so you should have been found not guilty when you were found guilty, or if you believe that your sentence was too long and you needed a lesser sentence. So these are the 2 appeal functions that we're going to be looking at under the magistrate's appeal functions. Now, the first appeal route that we've got is from the Magistrates Court, which is down here, up to the Crown Court. So this is where the case is first heard in Magistrates Court. That's where we get a decision of guilty or a guilty verdict, and a case is given. A sentence is given. This case will go to Crown Court. Now, normally this appeal route is only available to the defence, so it's only the defence that can claim this one, and that allows them to have their appeal on 2 factors, either conviction or sentence. So if your defendant pleaded guilty in Magistrates Court, so at their first hearing or one of their hearings, they owned up to the crime and said that they were guilty, then they can appeal against sentence. If they pleaded not guilty in Magistrates Court and they were then later found guilty, they can appeal against conviction firstly, because obviously they think they're not guilty and need that changing over, or they can appeal against their sentence as well. So it's conviction and sentence. Now, in both of these cases, the defendant's got an automatic right to appeal. That means they don't need any permission to do so. As long as they submit their appeal forms within the correct time limits, then they've got an automatic right to appeal from the Magistrates Court to the Crown Court. Now, at the Crown Court, the case will completely be reheard by a judge and 2 magistrates. So it'll be an actual proper judge from the Crown Court, and then 2 magistrates can sit on there as well, so you still have your bench of 3. Now, they can they can decide and confirm the decision made in magistrates. That basically means that they come up with the same decision as what the magistrates did in the first case, so there's no change to the outcome. Or they can decide to reverse the decision of the magistrates. By reversing the decision, it means that they've decided that the case isn't proved and therefore the person's not guilty on those factors. Now, for appeals against sentence, the magistrate can confirm the sentence. That means they agree, the Crown Court can appeal, the appeal can confirm the sentence. That means that they agree with the magistrate's decision. They could increase or decrease it, so that could be quite dangerous really. If you apply for appeal, you could actually end up getting your sentence increased as opposed to decreased. However, if they are going to increase it, the Crown Court can only increase it to the magistrate's maximum. So that's 1 offence is 6 months in prison and or a £5,000 fine. and if it's 2 offences, then they can increase it to a maximum of 12 months, but that's it. They can't go on to Crown Court powers. They've got to stay within the powers of the Magistrates Court. Now, if the appeals against conviction, the Crown Court can again confirm that conviction and say, yes, we believe that you are guilty, or they could reverse it, and that means that you are not guilty. Now, if it becomes clear that a point of law needs to be decided, by a point of law, it means that something's been it's an issue that relates specifically to the law, not just to the case in question, then we can have what's called a case-stated appeal, which we'll come on to next, which will go to the Queen's Bench Division of the High Court. And then, like all appeals, there is a final appeal to the criminal, well, there's a next appeal to the Criminal Division of the Court of Appeal, and then again, you can go to the Supreme Court. Now, a real big point to mention on the Supreme Court is it must contain a point of general public importance. So they can go from Crown Court. If they're not happy, then they can go to the Court of Appeal, to the Criminal Division there, and then they can next go to the Supreme Court if they believe that there is a point of general public importance. Now, if they're going to go to the Supreme Court and if they're going to go to the Court of Appeal, they must have leave to appeal. That means they have to apply and they have to get the Court of Appeal and Supreme Court to agree that their case is worth going there. Now, the next type of appeal from Magistrates Court, we have got the case-stated appeal. Now, a case-stated appeal is an appeal which is on a point of law. That means basically that there's been an error or a problem with the law, that the magistrate might have misapplied it or not fully understood it and therefore came to a wrong decision. So we need to remember that a case-stated appeal is an appeal on a point of law. This can be made by the prosecution or defence. It's only used by the defence if they're appealing against conviction, and prosecution if they're appealing against acquittal. So if the defence believe that they're not guilty when they've been found guilty, they can use the point of law appeal, it's case stated, and so can the prosecution if they're appealing against somebody being acquitted, which means that they've been let off on this occasion. Now, under this one, we're believing that the magistrates came to the wrong decision after they made a mistake on the point of law. Now, any mistakes on the point of law, so this time we've got a different type of appeal. So we've got case-stated appeal. Now, case-stated appeal will go from the Magistrates Court, past the Crown Court, and go to the Queen's Bench Division of the High Court. Now, the Queen's Bench Division of the High Court is in a better place. It's got more experienced judges to hear this appeal. And what they will be asked to do is the magistrates, or Crown Court if it's come from there, will ask to state their case, set out their findings or their facts and their decision. And then the appeal is then basically argued on whether the law on those facts is correct. They don't need to call any witnesses under this point. Now, it's important to know that it's heard by 2 or 3 High Court judges, and sometimes a judge from the Crown Court can sit there. Now, the powers that the Queen's Bench Division have got, they can confirm the decision, so they can basically say the magistrate's got the law correct, and they can make a decision based on that. They can vary, which means they could change what they've been said, or they could reverse. So they can send the case back. So they could say reverse it. That means that they're saying that the magistrates did make a mistake of law and therefore that person's acquitted or not guilty. Or they can send the case back to magistrates and they can implement the decision on the point of law. So the the High Court could make a decision and on the point of law, what was in question, and send it back to the magistrates for them to make a decision upon it. So they'll have to implement the law. Now, if the Queen's Bench Division, there is another appeal route that can go. So you can go from the Queen's Bench Division up to the Supreme Court as a final appeal court. But you need to have a point of law that's of general public importance. So it's not just an everyday point of law. And either the Queen's Bench Division or the Supreme Court must give permission or leave to appeal on those. So points to remember on case-stated appeals, it's on a point of law. So there's been an error when applying the law. It goes straight to the Queen's Bench Division of the High Court. Their powers are to confirm that decision, to vary it or to reverse. And then you've got your final appeal route up to Supreme Court. Again, on the conviction and sentence appeals. Now, conviction and sentence appeals are points to remember. It is only made by the defence. The case will be reheard by the Crown Court. So if it goes from magistrates to the Crown Court first. It will be completely reheard by the judge and 2 magistrates. There is a further appeal to the Court of Appeal and then to Supreme Court. But on these two, the top two, remember, we do need leave to appeal. If you go into Crown Court does not need leave to appeal on those factors. Now, you can get a decision, you can get a question on the appeal process from the Magistrates Court, and it does come up as a scenario like is presented on this page and as is presented in your handout. So if you turn to the page in your handout that says AO2 application, appeals from the Magistrates Court, you can see the Lucas appeal scenario there. Now, we are going to look at Crown Court in the next video, so the Crown Court appeals, so ones where cases have started and ended in Crown Court. Now, this is different, so you need to make sure that you're very careful on identifying which type of appeal process. Now, you can see that the question says explain the possible appeal routes for Lucas. So the things that we need to look over and we need to highlight first are, number one, the fact that he has been convicted. Being convicted, if you remember, means that he has pleaded not guilty at trial and therefore has been found later guilty. So if we make a note saying he has been not guilty at trial and later found guilty. So we've got that aspect there. We also need to note as well from this point that we have got an appeal in the Magistrates Court. So the fact that it's in the Magistrates Court will be using the appeals that we've just covered. Now, in the mark scheme, you do need to cover a number of points. So you need to figure out what he is appealing against, and then you need to give advice against this. Now, the first thing that he is going to appeal against, as we can see, is he wishes to appeal against his conviction as he believes the law on theft was not properly applied during this case. Now, an appeal against conviction, we have got two possible routes here. So we've got our conviction appeal first. So if we put that down there. And then we have got then the possible point of law, which would be our case stated appeal. So you've got that one there. So we've got two there. So if we just highlight on the fact that that he believes the law was not properly applied in his case. Then the final point that we've got, let me change to yellow this time, is the fact that he wants to appeal against his sentences. It feels it's too harsh on this factor. So the other point you would need to discuss is the possible of a sentence appeal as well. So we've got a couple of points that we need to discuss under this one. So the first thing that you would need to identify, so the first thing you are talking about, which is your top issue box. Now you would need to identify this aspect of the conviction appeal. So we will be looking at the conviction appeal first, which I've just noticed is spelt wrong, so there's Mr. T in there. So the conviction appeal, what we will be looking at here is the fact that you would need to state that he's pleaded not guilty at trial and then he's later been found guilty. Now, if you plead not guilty at trial and found guilty, so you would need to explain this point, not guilty and then found guilty would give place for your conviction appeal. So it would give you the right to go to, Crown Court under this one. So you would need to acknowledge that you would be able to go to Crown Court. Now, you would need to say as well under Crown Court that there is an automatic right to appeal. So please make sure you apply it. So once you've stated that the fact that if you plead not guilty at trial and then later found guilty, you have an automatic right of appeal to the Crown Court. That would be your point. To apply that point, you would have to say that the fact Luke has been convicted at trial would give him the option to go to Crown Court based on these facts. Now, the next thing that comes up after you discuss that he doesn't have to get any permission, it's an automatic right to appeal, is the fact that he's going to appeal against his conviction. So you would need to say, again, this would go to Crown Court. And he would have an automatic right to appeal. You would need to say that there'd be a complete rehearing, and he could potentially bring up the point of law, the fact that the law's been incorrectly applied on theft in this appeal, or he could then go to his next appeal, which would be your case stated appeal here. Now, the case stated appeal, you would need to acknowledge that a case stated appeal is a mistake on the point of law from the magistrates, and this appeal would go to the Queen's Bench Division. Now, this is not an automatic right to appeal, and you would have to get leave to appeal. So you would need to state you would have to get leave to appeal on that one to take it to there to let them look at whether the law of theft was applied properly in this case. Then the final element that you would need to talk about is your sentence appeal. Now again, your sentence appeal, because he's appealing against his sentence feeling it's too harsh, you would need to say that he has got a right to go to the Crown Court, and it's an automatic right of appeal here, so he could go to Crown Court for automatic right of appeal. You need to tell them the powers that they've got there, so the fact that they would consider the sentence, they could confirm it, so say it's the same as what the magistrate said. They could vary it, so they could increase or decrease that sentence, so you would need to warn him that he could have his sentence increase as well as decrease on that factor. Then the last point that you would need to mention is the final appeal court. So that would be your last thing down here to mention. Now, your final appeal court, what we're looking at here, is you would say that he would be able to go to Supreme Court for their final court appeal. However, they need to get permission from either the Queen's Bench Division or the Court of Appeal to go there, or Supreme Court, and then that would need a point of general public importance. Now, the fact that here it's just about the law of a theft not being applied properly, it probably isn't a point of public importance, and you'd have to say it's extremely unlikely for him to get an appeal on this one. Now, the final thing you can see here is the mark scheme for this and what you would need to talk about. So there are a few things that we obviously need to look at now. If you notice that on this side of the mark scheme, it tells you what marks you're going to be awarded for each level. So obviously, if you don't apply it, then you're going to end up in a maximum of level 2. And you need to refer to him as Lucas, he or the D. If you don't, that caps you into a level 2, so it is worth noting. That is important there. And then the following points need to be considered, so each worth 2 marks. So obviously you need to cover these as many as possible. Each of these we've gone through, so it's just working your way through the question on the certain elements that are available. So the fact he's pleaded guilty, that he has an automatic right to Crown Court on his conviction and sentence appeals. Sorry about that. The misapplication of law, that it can go as a case stated to the Queen's Bench Division. The right of appeal against his sentence. Now, each of these you would need to explain the point of law, but then refer back. So his right of appeal for a sentence, you'd say that he will be appealing because he believes his sentence of 5 months in prison is a little bit too long. So you do need each of the application, you do need to apply it. So once you've explained the point of law that went through on the previous page, you do need to make sure that you refer back to the scenario and apply it on each one. So if you use your writing frame to have each of these 6 in, so you'll notice there's 6 spaces on the issues. If you put each of these into the 6 issues and then explain, you can look at this side to make sure you've got everything you need in there, but you do need to make sure you apply it. So always refer back to the scenario and pull out facts from the scenario to substantiate the conviction appeal, the point of law, the case stated appeal, and then finally your sentence appeal. Hopefully this makes sense. Once you've had a go at this, if you look back a page from the appeals page, you'll see that at the top of it says appeals from the Magistrate Court diagram. Please make sure that that's done, and then you can see you've got some scenarios there. You could practice using this and writing out exam answers, so these would count as independent exam practice. Although they're not actual mark schemed questions, so from past papers, this Luke scenario is the only one that we've got as a magistrate's appeal route. So you can use the 3 scenarios there, the Janet scenario, the Sid scenario, and the Jeff scenario, as a means of going through, making your point about it, and then applying it. Remember, these are all magistrates, so you would need to identify the way for appeal, and then tell me about that appeal, then apply it to the facts of the scenario as well. Once you've done that, the next section, so your Crown Court appeals will be the next thing, and you would need to watch that video, getting all the key information and then applying it to the scenario at the end of the handout.